Thanks so much, everyone, for coming out. I'm Navruz. I'm a tenant paralegal at NILAG. I'm joined by my co-host, Hannah Tuschman, an immigration attorney at the Legal Aid Society. As folks may have seen in the advertising, there is going to be food. It's running a little late. So we're going to do our first section on Minneapolis, and then we're going to take a little break for food once it gets here, and then move on to our next section.
So tonight's panel looks back at the 2017 ICE Out of Courts campaign, when rank and file legal service workers collectively withheld their labor to force ICE out of the New York City courthouses, even though the law, their contracts, and the bosses all told them it couldn't be done. Starting in 2017, workers organized across offices and boroughs, walked out whenever ICE appeared, and created enough disruption that the courts were forced to ban ICE.
Today, we're experiencing renewed escalation. Republicans and Democrats have collaborated to increase ICE's budget by orders of magnitude. Masked agents spewing fascist rhetoric are going city by city, terrorizing our communities. Agents have murdered Keith Porter Jr. in Los Angeles, Silverio Villegas Gonzalez outside Chicago, Renee Good and Alex Preddy in Minneapolis, and at least 36 people in custody. At the same time, labor law insists that workers should only withhold their labor for narrow workplace demands.
So the question tonight is, when our tools as legal service professionals are insufficient to fight the attacks of the ruling class, how can we tap into our collective power as workers to defend our communities and win true justice for the working class?
First, we'll hear from Max, a worker and union organizer in Minneapolis. We have some questions and we'll also open it up to the audience. After that, we'll hear from some of the leaders of the ICE Out of Courts walkouts. We're scheduled to end around 8, but if folks want to continue the conversation, we're not going to cut it off.
Tonight's event is being recorded and it'll be posted to the ALAA YouTube channel.
As soon as he left the courtroom. I took him directly into custody. My client, like many other undocumented people. Want to come to court. And resolve their criminal matters. ICE has got to go. Shut it down.
They want us to accept the snatching and disappearing of our community members. They want us to normalize this dehumanization. I'm here to say today that we will not normalize this dehumanization. On Tuesday, December 5th, I witnessed Mr. Rojas Hernandez doing what he was legally obligated to do, and that was attend his court proceedings. At that time, he was snatched by ICE officers in what appeared to be with some assistance from court officers by allowing them access to restricted areas. After watching this arrest, legal aid attorneys had reached their boiling point. We wanted to make sure they knew this is not something that we're going to stand for, so we immediately marched out of the courtroom and began protesting outside of the courtroom.
Shut it down! What do we want? ICE out! When do we want it? Now! If we don't get it, shut it down! If we don't get it, shut it down! If we don't get it, shut it down!
Say what?
Hell no, ICE has got to go!
Say what?
Hell no, ICE has got to go!
Louder!
Hell no, ICE has got to go!
Louder!
Hell no, ICE has got to go! We're not leaving! Hell no, ICE has got to go!
Let them go!
Hell no, ICE has got to go! Hell no, ICE has got to go! Hell no, ICE has got to go! Hell no, ICE has got to go! Hell no, ICE has got to go!
All right, hopefully that gave folks a little taste. Very excited to have our panelists here tonight. There was one more panelist that we were hoping to have, Asalia Torres, who is a key leader in the ICE Out of Courts campaign, also one of the founders and the chair of ACLA, the Attorneys of Color at Legal Aid. Unfortunately, she had a personal emergency and couldn't join us last minute tonight. But we still have 3 other wonderful leaders of the campaign with us here.
To start, can each of you briefly introduce yourselves, where you were working in 2017, and what your role was in the union at the time?
All right, so I guess I'll start. My name is Mike Pate. I was a VP at the time at the Brooklyn Criminal Defense Practice. And I just want to reiterate, Azalia Torres and Jane Sampour were extremely instrumental in this whole action. Without them, this doesn't happen. They were instrumental in the whole organizing efforts. And I also want to give a shout out to the other VP that worked with me, Jeremy Fredrickson, not with me, with us. Jeremy Fredrickson was also a big part of this action.
And I am Daniella Korotzer from Brooklyn CDP. I've worn a few hats, health and safety officer, at one point Brooklyn VP, and more recently part-time rep on the BC&E. And I had no role except rank and file in 2017.
And a lot of institutional knowledge.
Thank you.
And I'm Michael Letwin. I was a public defender in the Brooklyn Criminal Trial Office of Legal Aid from 1985 to 2022, and from 1990 to 2002 was president of UAW 2325.
So before the ICE Out of Courts campaign, ALAA members already had a long history of fighting broader injustice, including for the 1987 Bernard Goetz trial advocacy and the 2014 Eric Garner courthouse die-ins. Tell us more about these fights and how they shaped ALA's culture going into 2017.
So first of all, just so much respect for the anti-ICE resistance in Minnesota and LA and beyond. And that's, I think, why this forum actually is important, is in this current moment in particular. So in our situation, I think it's important to understand that these walkouts did not come from thin air. Some of us grew up in the movements of the 60s and 70s and beyond. But in addition to that, we came into a union where there was also, by 2017, almost a half a century legacy of public defender strikes in 1970, in 73, 74, 82, 94, one-day strikes in 91 and 92, and at least 30 years of ad hoc, rank and file, anti-racism and direct action in our local, all of which is documented and you can read about at the ALAA 2325 WordPress unofficial repository of our union's history. And so in the second half of the 80s in particular, this was organized from below. And one of the major epicenters of that was the Brooklyn Criminal Trial Office that we all either worked in or work in today. I joined in 1985 in that office. And what was the situation in the union there was that it was characterized by an extremely democratic culture of debate and decision-making, of multiracial membership mobilization, conducted jointly with 1199, our support staff siblings, and addressed both immediate work conditions, but also broader racial, economic, and social justice issues. So, for example, in November 1987, we threatened to boycott Brooklyn criminal court arraignments, which won better conditions. And again, these are all from below. These are not things that the union-wide organization was calling for or organized. It all came from the rank and file folks in our office, in our unit. In July 1987, we organized a campaign for meaningful affirmative action. I'm sorry, we organized throughout the 80s for meaningful affirmative action at Legal Aid, along with people in other offices. And in July 87, we published an open letter condemning the infamous acquittal of Bernard Goetz, who had repeatedly shot Black teenagers on the subway. And that was something that was a little bit scandalous for some, even of our members, because here were defense attorneys criticizing an acquittal. And we made the point that we were not defense attorneys per se, we were public defenders. And we represent certain communities that are oppressed by the system. We were not there to represent or champion racist murderers on the subway. So we frequently marched during that period, as others have done here, Mimi and others, to protest the wave of racist murders in New York City at that point in the 1980s. So when the slate on which I was elected president came into office in 1990, we, along with people from some of the other places in the union, brought this culture of grassroots militant action to the union as a whole. And after losing office in 2002, a core of us in Brooklyn Criminal, which in this 2017 moment included Asalia Torres and Jane Sampour, Mike Pate, Daniella Korotzer, Susan Moritz, Steve Terry, Rafa Kidvai, and others who are not here tonight, together with union-wide attorneys of color and Black attorney caucuses, continue to lead from below, because we were not getting leadership from above, so we had to lead from below as we had done back in the 80s. And despite the resistance or the absence of union leaders in terms of these efforts. And so an example was what Navruz had mentioned, the 2014 die-in and march in Brooklyn, in which we protested the police murder of Eric Garner. And this was the same core or various members of it that then proposed the 2017 anti-ICE walkouts. Today, that same spirit is evident, I think, in the current membership of our union, including places like, and just including, not exhaustive list, NILAG, New York Legal Assistance Group, CAMBA, Bronx Defenders, all of which were out on strike in the last year, and which brought that same kind of militancy to the process. And also in our union's landslide support of for a free Palestine. And really, again, showing that issues of immediate concern at the workplace and in the courts are intimately connected with the broader issues.
Anything to add from other panelists?
In fact,
Pretty exhaustive.
And if I could just add one last thing about that, is that the 2017 anti-ICE walkout, I think it may be, in fact, to my knowledge, the first ever anti-ICE union job action that I'm aware of anywhere. And that's not to say that, that we deserve so much credit for it. It's to say that, these things can happen from below in a grassroots militant way when the moment calls for it.
We didn't take our cue from leadership. We didn't have a playbook. We just organized our asses off.
and someone's got to be the first. And this time it was us, but
And here's a prop from our, as you will see in the video.
So after Trump took office in January 2017, ICE dramatically escalated its operations, and New York defenders began seeing detentions inside and around criminal court. What did you actually observe on the ground in terms of ICE's actions, and how did the Office of Court Administration and court officers respond?
so pretty much right out of the gate in January 2017, public defenders started noticing that there was an ICE presence in the court. And every public defender gets out in the hall and does an immediate scan for any, well, usually regular warrant officers. And we already had sort of a system where we would inform people like there are some warrant officers outside AP5, just if you have a client in AP5, be aware. And then, but this put us into like hyperdrive with that. And it's not that there was zero presence of ICE before that, but it was pretty rare and mostly happened when ICE was at Rikers and had an office at Rikers, which a couple years earlier had been disbanded. So they were on our radar, but this was just nothing like we've ever seen before. And I went back to look at emails from that time period because I also never erased an email. And I was getting anxiety just reading them because we were panicked and we were asking leadership, legal aid management, like what we need advice. What do you want us to do? Because I think you heard some people describe what it was like to just have your client, you think your client's going home that day. Your client has no reason to think they're not going home that day. Maybe they're supposed to pick their kids up from school. Maybe they have a job that they have to get to. Maybe they're the only people that support that family and they're not going home. And they're not going home. And it was, clearly not as traumatic as it was for that family, but it was traumatic. Even if it wasn't your client, you saw it happening. And the most we got from legal aid management was we're writing a firmly worded letter to OCA, telling them how against this we are. But what I was struck by when I look back at emails is we kept begging them for something more. And in the end, we started coming up with our own things, like hiding clients in our office and going over to court and asking the judge to excuse the client's appearance for that day and telling the judge, no, I've seen my client today. My client can come if necessary. They're not far from here, but we're asking you to please excuse them. there were just things like that that we had to do. But we also started seeing more detainers in arraignments. So you think your client, just got your client out, but now there's a detainer that says like, no, this person's not supposed to.
ICE hold.
Yeah, I'm sorry, an ICE hold, like you got to hold this person for ICE to come. So, you know, we would be psyched that we got some now, and then all of a sudden you'd have this huge other problem that you were dealing with. So, you know, in terms of OCA and court officers, OCA, it was just like business as usual. Court officers were clearly actively involved. I'm not going to say all of them. You kind of, at some point, it was clear who they were, but they were actively involved in getting ICE there. And one of the reasons we knew that is because we had all these ways of changing up the court dates, because our assumption, I think this was true most of the time, is that the court officers would be going by what that person's court date was and tracking that information to ICE, or maybe NYPD was tracking that information. But we started having our clients sometimes not come that day and return themselves on a warrant on a different day. And one of the times that happened, there was like a long delay in bringing the file up from the warrant office, and all of a sudden ICE was there, and they would hide ICE in the back. So a lot of times we wouldn't see ICE until like the last couple of minutes when we thought we were home free, we're leaving. So anybody who was undocumented, even some people that were legal permanent residents, we just started scrambling to find ways to have them not appear in court. I mean, I can say one of the worst things that we had to do was, upon occasion, ask for bail to be set on our client in the courtroom, which was just awful. And luckily that didn't come up a lot of times. It was very confusing to the judge and to the DA.
In order to avoid ICE.
In order to, like, ICE would be outside, and we would know that, and we would ask the judge to put the client in.
Set bail, family would post the bail, and then it would get out that way, instead of walking out the door, which is our goal, to have them walk out the door, but not when ICE is hanging out in the hallway. So it was just another one of those strategic moves that we were doing.
I mean, by the time November 2017 rolled around, we hadn't gotten any real help or leadership or guidance from our management. And I think something like OCA reports something like 80 times ICE had been there, but those were their numbers, so I'm sure it was more than that. So I guess it was just very, very stressful, and we were like at our limit.
Daniella, just quickly, could you say what OCA is?
Office of Court Administration, they run the courts.
And that's they're selected by judges, or they are judges?
No, I don't think they're judges there, but they run, I don't know who, they're just administrators.
Okay. On November 28th, 2017, ICE detained Genaro Rojas Hernandez in Brooklyn Criminal Court. What exactly happened, and how did ALA members respond?
Well, I'll start with this, but I think Jane can finish it. You know, we had our union shop, Brooklyn Criminal Defense Practice, had several serious meetings. We invited our union leadership to participate. We invited management to participate, because we were all working under the assumption that we're in this together. Management always was trying to explain to us that the time is not right. We got this Padilla alert system coming, and it should be ready in November.
Explain what that is.
The Padilla alert system, as I recall, was a system that alerted our office-wide, citywide, where ICE was. I mean, I don't know exactly how it worked, but it was a system that, gave us a heads up. It was nice. It wasn't finished. It wasn't developed yet. It wasn't perfect, but it wasn't enough. And so, I had a special meeting with the officers of our union, with management, and they were telling us, management was telling us that, we're working with you. We want to work with you. We hear you, but please don't do anything drastic. And I remember specifically telling our leader, our management leader, that the shit has hit the fan. Our members are done. We met. You guys didn't come. We are ready to do something now. And I remember I was in my pickup truck. I was doing a telephone call going back home for Thanksgiving. And I had no idea that what I was saying, like now, really meant like right after Thanksgiving. So here comes November 28th. This client of ours gets snagged in the hallway. and Jane, myself, before I go into that, we had several union meetings to discuss what are we going to do next. All right, we've got these strategies, they're kind of working, but we need to do something more impactful. And we took a vote and we said, if this happens one more time, we're walking out. And we voted unanimously. That was the game plan. We had no idea that that vote that we took the Wednesday before Thanksgiving was going to materialize into a situation the Tuesday after Thanksgiving. But that's exactly what happened. And here we are in that scenario. And I'm in DV1, the domestic violence part for misdemeanors, with Jane Simpor and Jeremy Fredrickson. And we're looking at each other and we're like, are we going to do this? I mean, it's on. And we decided, yes, let's do this. And Jane and Jeremy reached out to their people, and Jeremy sent an email. Jane and I went like door to door, different court parts, and saying we are exiting the courtroom in 15 minutes. And back in those days, we didn't have any virtual appearances, so each courtroom was packed with attorneys waiting for their cases. And at about 11 o'clock, don't hold me to the exact time, but in 15 minutes, we all were going down the stairs in the elevators. The court officers observed it. We were ready. Jeremy had sent an email. People were in the office who didn't have to go to court, brought the signs. We were ready to go. And you just saw, the video is like, we were ready to do a picket, and, the shit hit the fan, and it was not prepared. We didn't organize it like Max was talking about. Our leadership was tepid, very tepid. And so this had to come from the rank and file, and that's what happened, and things just exploded. And as a result, Brooklyn Defender Services also joined in, who hadn't been unionized yet. And we just had a collective action, and it was just amazing, empowering, infuriating. And I'll let Jane take over because she was speaking to the press, doing an amazing job. One more thing, Jane, you brought up that point about the fear. Absolutely. But what mitigated against the fear was that we had so many people, so many rank and file working together. The solidarity, you could taste it, you could feel it, smell it.
And the civil division, which is reported, which gets lost very often in these discussions.
The civil division.
The civil division of a legal aid society. It wasn't just the criminal defense division that was confronting or doing these things, but
they also want that.
Yeah.
We came out to support them, but we also had other actions as our clients were being assaulted in the family court, in the housing court, and so on. So, but our comrades in the Brooklyn defenders really set the pace, but civil really mobilized to come out and support, which I think quelled some of the worst tendencies of management and how to deal with it. So it really caught on, certainly in Brooklyn, in the union as a whole.
It caught on. It gave everybody courage to do it. Brooklyn CDP were the ones that had to do it.
And it felt good.
Mm-hmm. It's like, when you go to the gym, you don't want to work out, after you do it, it's like.
Well, you can see it in the video, right? The video speaks much better than any of us here in terms of describing, showing what it was like and how empowered people felt, how angry everybody was, how clients came out of the courthouse and some of them joined the picket line.
Yeah, beating the chance.
Yeah. So, I mean, it was really seen as us standing up for our communities, which really is ultimately the thing that public defenders should do, right? I mean, of course, we should represent our individual clients. And we do that to the best of our ability. But it's a bigger thing than that, especially when it comes to the union.
Yeah, especially when management says, what about the clients? I don't know if this is going to another area, but the clients supported it. Yeah, you know what? I'll just say a couple things. The clients joined us in the march and in the outrage, and management's manipulative, you can't abandon your client. This is not an abandonment situation. This is like us working together for our clients in a different format.
And
in
look,
a larger format.
And that message always has to be reminded because, new management comes in and they're always going to say, you don't care about your client, and it's an age old thing. It's a cliche at this point. All right. You're not abandoning your clients by acting union strong in a rank and file style.
and this was even more clear than when that question often comes up, which it often comes up associated with us trying to, what are we going to do to get better living wage or, something for ourselves. Here, and I'm sure there were clients that were irritated to have their cases delayed that day. I have no doubt about that. But you can see clients and hear clients cheering us on there. And it also is like, yes, there is an inconvenience to those clients that day. But some of our clients, we are handing up on a platter. We were a part of getting them to court, and it was just felt terrible. So, in balance, it just wasn't really hard to figure out.
And by the way, if I could just add, the striking nurses in New York City at NISNA, I'm sure are being accused of the same thing.
Yeah.
Like healthcare workers always are when they go on strike. How can you abandon the patients? It's the exact same kind of issues.
So before this day when you walked out, what were the conversations in Brooklyn CDP about responding to ICE arrests? How did you all go about deliberating collectively? What were your demands and what leverage do you plan to use to win them?
So as Mike described, there was this extended period of discussion. And, it took us some time, as I recall, to get to the point where we could have unanimous support for a walkout in response.
Yeah, we started out with having educational sessions about the legal rights. The immigration unit came in and talked about what we can do and
But on the union stuff, even, right?
Right, but I mean, it evolved.
Yes, it evolved, right? And that's the process of trying to forge a consensus from below, right? And it's not particular to this. It's that's the nature, right?
This was 11 months, from when this started to when we walked out.
Right.
So,
and I should also add that after this walkout on November 28th, and I think there was another one. Well, anyway, the point is that it wasn't an even thing. In other words, we did this thing. We then organized a rally for December 7th, which
week later,
we'll get to, which was very well attended. But then Brooklyn no longer was in the forefront after that, partly because I think they had backed off a little bit on Brooklyn, ICE had maybe, but they were turning their attention to other boroughs, and other offices of the union in other boroughs began to take the lead. So Queens at one point, I think in April, was the point. Well, actually, no, first there was the one with Ron Sylvester that we just saw up here where he's describing what happened, with his client. That was in April. But then the action shifted to other boroughs where they were experiencing it, and they began to take the leadership. I mean, we kind of ignited something, but they took it and they ran with it and they got ahead of us. And we had to sort of get reorganized to support that then. So the point about all that is that things don't move, in a continuous line or a continuous pace. They go up, they go down, different places, become the epicenter. It all can happen very quickly, as we can see in the current moment. And I think the point, therefore, is that we need to be able to rise to the occasion and re-rise to the occasion and get reorganized and reaffirm and draw the lessons, but also whenever there's a call for solidarity to step up for it.
Well, that's what rank and file is. It's not one leader. It's decentralization. All right. So sometimes Queens leads, sometimes Brooklyn leads. People who have different specialties lead. It's not just top down. Wait for the leader to say something. That's not where we're going to get our power.
And we had a very simple demand. It was ICE out of the courts.
Right.
And at that point, even in New York City, there was tremendous popular support for that, just as there's popular support today against ICE. But in New York City, almost 10 years ago, that was certainly the case, which is why we could do this. In other words, why we could do it even though we had a no strike clause in our contract, even though the courts, were basically saying you're violating the rules, the court rules. Even though management was getting calls from the city administration and the court administration saying, what the hell's going on? And then management would call the union leadership and say, what the hell's going on? And then the union leadership, not us, but I mean citywide at that point, was calling our reps and saying, what the hell is going on? But despite all of that, because of that political moment, because of this unified action, and despite all the barriers, the no strike clause, the fear, all the different things, this rolled out very quickly with tremendous popular support, got a tremendous amount of press. It really brought attention to this issue of people being snatched in the courts. It got all these politicians who hadn't done a damn thing, all of a sudden wanted to be somehow associated with this and take credit for it. Management, same thing. Union leadership, same thing. One of the earliest supports we got for this walkout was a tweet from the Kings County District Attorney.
DA's office. You were aligned on one issue.
The DA of Kings County, Brooklyn, New York, sent out a tweet saying, basically in so many words, I stand with the walkout, against by these public defenders. So
after that, other DAs and other boroughs did the same thing.
Right. So again, I think the point here is that often we should of course be concerned and be aware of what can you do legally and what don't you have legal protection for. And we were very acutely aware of that. And it's always important to be honest with our members and in the discussion, because people have to know, and take risks with their eyes open. But the point I think really is that when you take those risks and you do it together, you have a power that goes well beyond what the formal rules may constrain. And that goes to this issue of general strike or strikes in Minneapolis or anywhere else as well. Of course, there are no strike clauses in all the union contracts. It doesn't mean if you're united that you can't still do it.
Gotta be united.
Pretty much every person in a position of authority attacked the workers for the walkouts, as you all were getting at a bit. The joint council minutes that I reviewed describe LAS management's panic calls to the union. A spokesperson for the court said, quote, "By you doing what you did, you are disrupting operations. We won't have that." The president of the New York State, the president of the New York State Court Officers Association, the union for the court officers, said, quote, "They do it again, we will lock them up." Why were judges, court officers, and management all against workers fighting to protect our clients from ICE? And despite all that bark, why was there no substantive retaliation against the workers?
Well, I'll take that one. They were serious about arresting us, and just like you see in Minneapolis and about, preaching to the converted, they made up things that happened on that day. They said that the lawyer had attacked them. Then they said 4 legal aid lawyers had attacked court officers and ICE and were trying to hurt them. They said that lawyer had shouted to our client to run, which is ridiculous. So they were serious. I mean, why were all of these institutions kind of lined up the same way? Because the job of the criminal injustice system is to keep things rolling. Status quo, lock people up. And ICE being there really fit in with that. That wasn't a contradiction to what the system, like OCA, I don't know that they weren't trying to get ICE there, but it certainly wasn't inconsistent with what they thought should be happening in that court building. And even our management, look, I'm not going to put legal aid management in the same boat because I do think that people cared about what happened, but in the end, they cared more about their contract with the city. And they were like the thing they were the most panicked over is whether we walked out of arraignments, which is really the focal point of the city contract where we pick up all of our clients. So, I mean, look, they were really all lined up to just keep the machine running. And what we had to do was make it so that machine could not run, that they couldn't do it. And why did we get in trouble for that? Because it was all of us. Because what are you going to do? Like arrest everybody from legal aid and Brooklyn Defender Services? And there weren't even other attorneys stepping up to say yeah, I'll take those cases, because judges were threatening, well, I'm going to give your cases to some people. Were like BDS, even BDS's management said, no, we're not taking those cases. So even the private attorneys that take on indigent defense, the 18B attorneys, they weren't agreeing to do it. So, I mean, that's the answer to that question.
if I may, there's another piece here, which is again, the civil division, which gets lost in this. Your actions cascaded into memos being sent by people in the civil division to Fern Fisher Branding, who was the administrative judge of all the housing court and so on. And they actually issued a memo in sympathy with and instructing judges that if they felt that there was a danger to people showing up for the cases, because landlords were calling ICE against litigants who were taking them to court for repairs. Also, many of our clients at time in the family law were women who were sexually harassed and so on, and very often pressured by their landlords and exploited if they were undocumented. So, I mean, there were all these ramifications of what was going on. But the fact of the matter is that in the civil venue, because of this action, it actually cascaded to the point of them saying that they would do very often in camera sessions. That there were also trials that would put off because they knew that ICE was coming into particularly the family court and definitely the housing court as well. So it was so successful in that sense that even in an informal basis, as I said, Fern Fisher Branding, who was the head of, went along with and issued orders, and they actually ordered that ICE presumably couldn't come into the housing court and so on. And that was right around the time when we were, post 9/11, when we were getting the metal detectors, which we hadn't had previously. So I'm not sure you folks are even aware of how successful and how important, and it actually forced management, Adrian Holder and the like, those folks to not unsympathetic, but as you indicated, be more contract oriented to try to work with and convince the court administration in those civil venues not to either have the alert system that was in effect or literally to be able to have people in camera or otherwise adjourn cases if there was indication that ICE was there. So it was enormously effective what you folks did. And you forced a lot more concessions from management that affected the well-being of our clients.
Just hours after the first Brooklyn walkout, ALAA President Debbie Wright threw cold water on the workers' action, saying, "This was a work stoppage, which under contract is a problem. We don't want to be accused of abandoning clients." The following month, ALAA leadership invited the city council speaker to an ICE out rally over the workers' objections. Why did union leadership favor a strategy that stayed within the confines of labor law and relied on relationships with Democratic politicians? And why did workers reject that strategy in favor of exercising their direct labor power?
So, I mean, I think some of it is what Jane was just referencing, sort of people's institutional roles. And I think it is also true, certainly at legal aid, and this may not be true of other employers as much in other industries. But at legal aid, certainly it is true that, many managers, I think, did appreciate and actually privately want us to do some of these things. I think in the past, some of the managers, maybe many of them, even appreciated when we would threaten to strike or strike over working conditions and benefits and compensation because they too, benefited from that rise, and they couldn't do it because they were unprotected under labor law. But I think in terms of union leadership, and the same is true of union leadership, but I think, in our union in particular, what happened was, and this goes back to an earlier time, that union leadership, the leadership of our union in the 2000s and 2010s, had sought to replace what I described earlier. That is our tradition, our union's tradition of bottom-up democratic militant trade unionism with kind of a top-down typical UAW version of business unionism and bureaucracy, based on building ties largely with Democratic politicians, while in our case at least, doing their best to scare union members into passivity. and acquiescence, basically, to whatever contract, for example, they brought back to the members from bargaining, which was usually not very good. And the reason it wasn't very good is because they were not organizing members to be a credible threat, to be leveraged to get something good. I mean, that's the only way you ever get anything good in life. Certainly it's true in union negotiations. It's true in the work that we do as public defenders. If your client is not at least appearing to be willing to go to trial, you have no leverage to get a better plea. So these are like all elementary things about our work, about unions, and about life as a whole. And so the result in our union of that kind of switch in the union leadership's position on these issues meant that there were givebacks, there were bad contracts, there was a surrender to censorship of our free speech rights at work, which had been quite robust. Over, by the way, the issue of Palestine, because more than anything, management wanted to silence us on Palestine at the workplace. The union leadership at that point gave in on that. And a lack of action over conditions for clients and staff, whether in the offices or the courts. And that's why this kind of constellation of Brooklyn rank and file to begin with, attorneys of color, Black attorneys, had to lead from below. That's why union leaders first tried to demobilize our response to ICE or defang it, distance themselves from it. And then once it happened and was popular, tried to co-opt and take credit for it. And also steer it into this kind of Democratic Party politicians kind of thing. And so the speaker, whose name I forget, the speaker of the city council at that point, Veverito or something, he had been, I guess nominally supportive of certain good things, but also was known as being, terrible on like police abuse and all kinds of issues of great concern to us and to our communities. Mm-hmm. And so that we didn't want him at this December 7th rally that we organized from below, Brooklyn in particular, at the Brooklyn Borough Hall to demand ICE out, at which hundreds of people came, both our own members and our community allies and allies from other unions that we reached out to and management. But it was a union rally. And that was the rally that Jane spoke at that you saw her on the video. Tours. Yeah. And they basically, without our knowledge, the union leadership agreed to have the city council speaker come and speak despite our previous objections, despite the fact that we were supposed to be in control of the speakers and program. And as a result of that, not only did they speak, but they were booed by community folks who were there, like, what the hell, And that also made us look bad because, like, why are we, these rank and file activists who are doing this work, now putting this, terrible city council. We took a credibility hit. Yeah. So while some Brooklyn union leaders bought into that approach, our activist core that I described earlier, and many members in our office, continued to argue that the entire ICE Out campaign depended on maintaining rank and file direct action and control and credibility with community groups. And I think more broadly, what this reflects is the overall refusal of labor officialdom in this country to organize union members or to support union members in exercising power at the workplace, which is why private sector union density has plummeted in this country to 6% today. It's why labor union bureaucrats, including our own international UAW leadership, may talk about Trump's attack on federal workers and talk about Israel murdering people in Gaza and talk about the ICE terror in Minneapolis without actually organizing workers to stop it or supporting workers when they try to, as the sibling from Minneapolis was describing there. And that's why we've had to lead from below in UAW 2325, why many of us here are members of UAWD, the rank and file caucus in the UAW, why we have Labor for Palestine, and why there's a proposed resolution at our January 10th UAW 2325 Joint Council meeting coming up next week about joining a general strike against ICE. Because unless these things come from below, they're not going to come. And I just want to finally say that one place, ironically, since it's Minnesota that we're talking about in this moment, rightly so, Minneapolis, one of many places to look historically for an example of where that took place in a highly successful way was the 1934 Minneapolis Teamster strike and general strike. And of course, then in Minneapolis, also the George Floyd Black Lives Movement. But there are examples of where this has taken place, and that's what we need to emulate.
I mean, if you're going to stick within what is allowed under a contract, what's allowed under labor laws. We're talking about decades of chipping away at workers' ability to organize themselves, right? So I don't really have a problem, and I think it's the responsibility of union leadership higher up to certainly let us know when we're stepping into an area that's shaky, that, you know, and I think we tried very hard to also, you know, I mean, I know we're making it sound like we just like, we're like grabbed a flag and went running out, but we, all those meetings leading up to that, we had talked about whether to walk out of arraignments, which we knew was like the nuclear option. And we actually didn't do that, even though they seem to think that we did. We also always look out for the people who are on probation. You know, like maybe, you know, I don't remember what we did in this instance, but in general, we've always been like, you know what, maybe you get it, you know, stay in the back, you know, or whatever it is. But I think the issue is that once you've told us what we're allowed to do and what we're not allowed to do, and frankly, if you follow the rules, you're not allowed to do anything. Really, right? So then how do we function? How do we do this?
And we did the walkout on Eric Gardner.
And then I expect you as leaders to say, but we got your back. Instead of just taking credit later for it.
Well, after telling us not to do it.
Right, after telling us not to do it.
What was the first sign of the walkouts working, of kicking ICE out of courts?
I think the way Jane described it, when we were all just walking out.
But I mean, going from there, right? You're saying like what happened after this?
Yeah, at some point, ICE stopped coming into the courts.
Oh,
Yeah, I mean, before we officially won. So I don't think there was a like officially,
We'll describe what officially was, and then we'll work backwards.
you know,
When they
it was
passed the law.
it was a passage of, I can't remember what the law is called. Do you remember?
Protect Our Courts Act.
Yeah, which was 2 years later, I think, right? But after we did
And
this a
describe
couple
what
of,
that is.
well, they can't come into the courts,
They can't come into the state courts
into the state.
without a warrant.
But they had really, we were just not seeing them that much past a certain point. And they wouldn't give that to us. They wouldn't say that they had done anything, but there were clearly been discussions behind the scenes that, like, you know what, this is not worth it. Now,
It's not a
look,
good look.
it is not a good look. They would wait at the corner for our clients. They would wait. I had a client that was picked up, like, I had walked him a little bit. I thought it was okay. He went at the subway station. They grabbed him. So I don't want to make it sound like we prevented this from happening. We just did the stuff that we could do at that point.
But they did back off in practice, you know, unlike today, you know, where they're really not backing off, as Mimi pointed out. They're just, you know, they're still doing it, and they will still do it. And but in New York at that time, in the Trump 1 years, it was still a moment where, in New York City at least, they felt they couldn't go down this road. And because of these actions that have taken place, and because of the kind of the snowball effect of all the powers that be basically saying, oh yeah, this is not a good idea, you shouldn't, you know, do this, I shouldn't do this. You know, it meant that ICE did in fact back off from the courts, at least well before Andrew Cuomo had to sign a law that said they couldn't come in without a judicial warrant. And again, that shows the power to affect things regardless of what the law is, regardless of the no strike clause, regardless of the fact that the courts had not issued there was no law saying they couldn't come in. As a practical matter, the direct action on the ground meant that politically they simply could not do that.
yeah, and another way of looking at it too is that, you know, before the walkout, we were getting emails on a daily basis that, you know, ICE had taken one of our clients, and those stopped for the most part. City council was starting to meet. They passed a resolution, so it was a gradual effect. But I do think for like my personal practice, I could take a breath. You know, all those strategies that we had to do. You know, winking at the judge, adjourning cases, having our clients warrant, having clients have bail set. You know, slowing work down so we could reach our clients' families. Like if we had a client that we thought ICE was going to take, we wouldn't do the case until we could reach the family and they could bring money. So that part of our practice kind of died down a little bit. So we felt a palpable change. But the Protect Our Courts Act couple of years.
We talked about, I think as part of this last question, how after the walkouts, more establishment institutions started responding to the crisis, including in April 2019, OCA banning ICE from entering the courthouses without a warrant. In September 2019, Legal Aid sued ICE. And then it was in December 2020 that Cuomo signed the Protect Our Courts Act, which prohibits ICE from arresting people who are going to or leaving state or city courts unless ICE has a judicial warrant. Why did these institutions not act of their own accord when ICE first started entering courthouses, and why did they finally act when they did?
I think the reason why they didn't act earlier was sort of what I was talking about before, where their job is really just to keep things moving, regardless of what families or, community members are crushed underneath that machinery. That is what their job is. Why did they eventually, not give in, not from, the depths of their hearts, obviously. I think it's similar to what we're seeing in Minneapolis, where there just becomes a critical mass over a certain period of time of, we got very good press, and there were just people weighing in from other organizations and also from establishment, like we mentioned before. The DA's offices, their position was that they're not about preventing somebody from having their day in court, but they also were worried about their witnesses. They were worried about maybe women would be calling DV cases in less because you may want this person out of the house, but you don't necessarily want them out of the country. So they had their own institutional reasons why they were worried about that.
Well, also they were probably worried that their witnesses, their undocumented witnesses, would be snatched.
And or that they just wouldn't come to court. Like they would be scared and they wouldn't come to court.
Complaining witnesses.
So, people had their own, all the institutions had their own reasons, but city council, this was being taken up at city council, and before Cuomo signed the act, Cuomo had an executive order. Do you remember what year the executive order was? I think it was like 2019 or something. But basically everything started kind of falling in behind a certain perspective on this issue that I feel like you see happening in Minneapolis. But in the end, I think the bottom line is we just made it too hard for them to do business like this. I think that's what it really came down to in the end, is that ICE in the courthouses, even OCA, was like, this is not, we can't lock people up as well this way with them here. So I don't know, that's my opinion.
There's also power competing relationships. Like the court officers were not in love with ICE, and these structures have their own power.
Actually, the court officers were in love with that.
Oh, no, okay.
But yes, I think your point. I understand your point. I think that it's what Daniella was describing. The criminal injustice system is an assembly line, and the whole thing is how fast can the system make it work. That's how the judges, the administration of the courts get judged. That's how the judges in part view us. Are we facilitating or obstructing? And everything else that goes on. They're all judged, everybody's judged and ranked and evaluated on that basis in large part. And so anything that slows down or obstructs it, and that's why we actually have tremendous power in the system. And that's why, coming out of our 1994 strike, then Mayor Giuliani, who crushed our strike, set up a bunch of non-union defense organizations to make sure that our power, that is the union power of legal aid attorneys, was reduced in the courts to obstruct. And he said as much. He said, I'm not going to let them get away with this again. And we're going to do this. We're going to take millions of dollars from them, give it to these runaway shops, all of which, except I think one now, we have reorganized into our local. I'm very pleased and proud to say. But which nonetheless were set up for that express purpose. It was to have non-union alternatives to undermine our power to obstruct the criminal and mainly the criminal injustice system, because that's the thing they care the most about.
But there also is that hierarchy, like the court officers in the civil courts, they hated the ICE officers because it was a matter of their control, not because ideologically they had any different kind of racism or anything. But these are our venues. You don't tell us what to do. You don't disrupt the proceeding. So within the system, this
That can
kind of
happen, for
hierarchy
sure.
between a border patrol and.
But that certainly
And
was not the
government.
case in the criminal courts. In the
Mhm.
criminal courts, the court officers saw these as their
They
brother.
assisted.
I mean, we started looking at like Twitter accounts and stuff from some of the officers, they were vile. Vile. I mean, I couldn't look at those people the same way again, you know, they were like Nazis. And I mean, think about it. They were going out of their way to have connections with ICE officers and get those ICE officers there and delay our cases enough that day.
Hold the
for ICE
file.
Officers to get there. The file would disappear.
So it couldn't get
Now,
called.
so they couldn't, so you keep saying like you get nervous and you're like, well, why?
Why isn't my case
isn't
being
my case
called?
being called? And you just have like a bad feeling and you're usually
Mm.
right. But what I always imagine happening is at the beginning, OCA and the court officers are like, yeah, we fucking hate those legal aid lawyers. They suck. And then towards the end, OCA is like, guys, we can't be doing this.
And another thing.
This is really jamming things up like
Yeah.
it's on the ice in court.
And just one more thing to talk about on top of that is we already established that we're willing to do it. And they're probably thinking they'll do it again. And I have reason to believe, I wasn't in the room, but management, might have been saying that to various politicians in different meetings where I can't stop them. I told them not to do it, that to hold on. But once you do it, you form a reputation and you can carry that momentum. Like you show that you're willing to do it, they fear that you're going to do it again. And so then the assembly line just comes to a grinding halt.
Thank you so much. We're gonna open it up to audience questions in just a sec, but first, Hannah, I have a few questions for you. You're a current immigration attorney. The Protect Our Courts Act that we talked about kicked ICE out of courts under state and city jurisdiction, but immigration court is under federal jurisdiction. In the second Trump administration, what is ICE doing in immigration court?
So a lot of people have probably heard about this in the news. Starting in the spring of last year, ICE officers who are masked and armed started standing in groups in the hallways of immigration courts in New York City, other cities as well, and arresting large numbers of people who are there for routine hearings. And hearing you guys talk about witnessing like the violence of it and the trauma of it felt very real. Most of these people though don't actually have attorneys because there's not universal representation in immigration court. And there's really it's not realistic, even if we had much more money that could even exist because there's not enough lawyers. Currently, we're not seeing as much of an ICE presence. There aren't as many arrests in the immigration courts as there were in spring or a few months ago, but they're still happening.
Our legal advocacy only works if the ruling class is interested in maintaining the veneer of due process. But speaking of immigrants, Trump has said, quote, "You can't have a trial for all these people." Have you seen this attitude manifest in your practice?
Yes. So right now, many asylum seekers whose cases are in the immigration court system are actually being ordered deported without having a trial because of something called pretermission. So basically, immigration judges are oftentimes ordering a person deported who has a pending asylum application without considering the merits of the application. Sometimes they're ordering people deported to a third country that they've never been to before and saying that that person should seek asylum in that third country. Sort of the background context of that is that the immigration court system is housed under the Department of Justice, and immigration judges are attorneys who are appointed by the Attorney General, and they basically act on behalf of the Attorney General. And under the second Trump administration, a lot of immigration judges who are considered more friendly to immigrants have been fired. The immigration judges who are left are pretty much seemingly terrified of losing their jobs and pretty much just like doing the administration's bidding. And you know, like I mentioned, already most people in the immigration court system are not represented. But cases are largely being pre-terminated for asylum seekers, even who do have representation.
Well, thank you so much to all our panelists. Thank you very much to Hannah. Please give a round of applause. Now we're gonna open it up to audience questions.
I have a,
Go ahead.
I have a follow-up to the last thing you said. Isn't there a rule change about to go into effect too that says pre-termination is not reviewable unless it's like a panel of judges en banc? And so basically all of those termination cases are just like, there's nothing, pretty soon, there's nothing that can be done judicially to stop it.
A rule came out today that I haven't had a chance to look at yet because I was in meetings all day. Basically, the appeal process for immigration judge decisions is that you can first appeal to something called the Board of Immigration Appeals, which is also housed within the Department of Justice. Do you want to take this?
Yeah, I'm also an immigration attorney at Legal Aid. So the proposed rule is basically gutting the Board of Immigration Appeals, and the proposal is that first, all appeals need to be filed within 10 days of the immigration court decision instead of 30 days, which is the current default. And second, all appeals will be summarily dismissed unless a majority of the judges on the Board of Immigration Appeals vote to accept and hear them on the merits. So then the only remedy is to file a petition for review with a federal appellate court. You also, like we're seeing this with, over the last year, the decisions that they're choosing to publish, at the Board of Immigration Appeals. We've only had one published presidential decision that is like pro-immigrant, and every other single one has been based of negative where the immigrant lost. So we don't know if like this proposed rule is actually going to go into effect, but I think it kind of just shows that like the Board of Immigration Appeals is a joke and it's not a place where you can meaningfully seek review of the merits of your claim.
Thanks. I didn't mean to get too much into the weeds, but just it's getting worse. Yeah.
I was just gonna say, firstly, thank you for organizing this and thank you to all who were speaking. I really appreciate this conversation, especially in the climate and especially with this upcoming hopeful membership meeting that we'll discuss at JC on Tuesday. But my question was more about y'all were very successful in immediate mobilization, and I find that amazing and very impressive. Like the fact that it was like, okay, vote right before Thanksgiving, Tuesday it happened. Okay, we're ready right now to do this. And you mentioned folks being ready in buildings nearby that weren't in court that day with like signs and everything. Could you speak more about like the prep that went into that and like kind of like the action plan? Or if I know there wasn't much of a plan, but you were ready with some sort of like chants and like signs, etc. So I'm curious about that.
Well, we could all answer that. You know, I mean, a piece of it.
It really was months and months.
Right.
It was like, I mean, so, you know, this really started, you know, getting bad in January, and it wasn't until like November this happened. But I don't remember how we had the signs. I think, what did we do? They had the signs. So there were some UAW wheels.
Well, I made these signs, whatever they are.
It was printed.
Yeah, I just made these.
So that's the answer.
I mean, people did different things, right? I mean, some people made handmade signs. You'll see them in the video. As I said, you know, a bunch of us had been organizing for a long time, you know.
We
so
had flags from prior rallies in our offices. If you come into my office, I have like 20
Right,
bills.
I
I
guess
should
we got the
bring back
flags, right.
here. But, you know.
But politically, I mean, so that was the logistical stuff.
Right.
I mean, the much bigger challenge, the real, that wasn't the challenge. That stuff, these things were not the challenge.
No.
The challenge was getting to a point where we had consensus to do this, and that took a lot. I mean, and you know, we, in a way, it was typical of the rank and file meetings we'd have in Brooklyn, at least around.
We meet regularly, you know, we meet regularly, not once every 6 months. No, we meet even when there's no action going on. Like
But I
once a
mean,
month.
we would take up different issues prior to this.
Right,
that
we have,
required
Brooklyn
action.
Criminal Defense Practice has an action committee.
Right,
And-
but it also should be said that it wasn't like everybody started on the same page.
No,
People
We,
get very nervous about walking out
Yeah.
of court because, and the other thing I'll say is that, you know, you really are not supposed, is it insubordination if you are ordered to do something by management and you don't do it, right? I mean, we were very aware of all of that. We did not tell management anything that we were doing, and we didn't really tell the union heads either, except that we kept saying something's got to give. You know, we're at the end of our rope. Like it wasn't.
why didn't we tell the union leadership?
I mean, because we were going to be told not to do it, and you know, I mean, one thing that had happened that you remembered, I didn't remember this, with the George Floyd protest, or maybe you remember that. Eric Gardner, is like, we had planned on doing a die-in in the court, and we had informed the head of our office, and she was just like, oh, hell no. You know, so we ended up doing
the
it.
court office were ready to arrest us.
'Cause they
put us in
knew, right?
handcuffs. A die-in was gonna take place on the first floor of 120 Skirmahorn. And we got word that was gonna happen, and we changed our die-in in front of the House of Corrections, Brooklyn House of Corrections, so we pivoted. Don't underestimate like the power of one-on-one conversations. If your shop meets regularly, you start talking while you're waiting for your cases to be called, you know. And so I just think it's just a building process.
But we learned from that, like, we
Right.
don't need to tell anybody what's going. The other thing is, we didn't know what day it was going to be. It could have been a month later. I don't think we were thinking it was going to be like around the corner. So we couldn't have even informed the head of our office exactly when it was going to be. But we also didn't give enough information to be told that we couldn't do something. So I think that we learned from, you know, past actions and positioned ourselves as best as possible so that people would not, hopefully not get into trouble for this. But we did not know until we were running around to court parts and telling people, like, let's go. We did not know if people were definitely going
That's
to
true.
come out. Like, I remember going, and especially like really junior people, you know, there was certain, it kind of had a momentum at a certain point, but you'd be like, lawyers usually sit in the front 2 rows, people sign their cases in, you're really intent on having your case called. Like, you know who's ahead of you online, and, you know, you're very aware of it. But we were just like, gotta go. And I don't think we knew until then that it was going to be
That people would do it.
like really as successful as it
You gotta
was.
take that leap. And if you've prepped for it,
Well, yeah,
odds are,
build up until
yeah.
you lit the spark and then you saw.
You can't just send one email
Right.
and say mobilize. That's not how it went down. We begin to trust each other. We've heard each other's perspectives. We meet regularly. We have one-on-ones, you know, face to face. All that adds to a solidarity based on trust, you know, and that we have each other's backs.
So I'm interested in a little more information about their client's involvement or even just the reaction. I'm, you know, just imagining, like Daniella was saying, like you're waiting for your case, your client's in the courtroom. Like, what were some of your clients' reactions when they were like, oh, my case is being called next? JK, my lawyer is gonna go walk out. Like, what did that like look like? And I'm sure it's not all the same, but I'm just interested if you like remember a few examples.
I mean, I don't remember my particular situation. I must have blocked that out in some way. But sadly, most of our clients don't really expect things to move very quickly. So I mean, and we also, I think it was like an hour before lunch or something like that. So we kind of, I don't think there was a thought that we're gonna be out all day, you know? So it was really gonna be like a delay of about an hour, and really, and it's kind of sad, it's very sad to say this, but our clients, for the most part, is sort of understand like what a shit show criminal court is.
It's an all day.
It's an all day thing, but I mean, look, I'm sure we upset some people. I'm sure, you know, because
There are exceptions, but I will say that this is just one example. Don't underestimate your clients in the public defense sphere. Don't underestimate their appreciation of fighting. And even if it's not their fight on, getting the case adjourned, if they see you doing something like that, it kind of relates back to their case. Oh, I got a fighter. You know what I mean? And there might be an exception or two, and those are tough. Those are tough cases. But I would say for the most part, like the majority, vast majority, the clients got to see their attorneys fight in another world, in another perspective, venue, just like multi-layer, multi-dimensions of our fight. It just, I think, enriched their perspective of us, in my opinion.
Yeah, and I'll comment / response to the answer is that like multiple people will say like it's the question that in a way people ask, like, what about your clients? But to me it's like answers it in almost the exact opposite way, that it's like actually it's quite how I'm thinking about it is like it's very humanizing actually for your clients, because it's like we're all people. It's not just like this lawyer whatever client relationship, and so it's really nice just to be hearing this about like and involving the client as like a human being,
especially the way Jane explained it. It wasn't like bye. No, Jane included the story to the client, and the client's like, all right, let's go.
Yeah.
It's what clients, I think, for the most part, want to see in their lawyers, and at a whole different level of drama. It's not just on an individual case, important as that is, but here are lawyers telling the system, fuck you, we're doing this. And we're doing it on behalf of people that are being messed over here. And I think the estimation of public defenders at that moment, in New York City was probably at the highest point that it could have been.
Thank you.
Any other questions?
I just have a question about the story. When you guys were saying you weren't telling union leadership, do you mean like UAW staff or your own LAS union? Because I'm from NILAG, so like our union leadership would be like planning this. But I'm saying, are you like, you were hiding it from, or just not bringing them in on?
We weren't hiding it. They just weren't relevant.
Yeah, okay.
And it wasn't the office level or the unit level leadership, which was very much involved, as Mike was the VP there, in all of this. It was the union local wide leadership that, really hadn't.
Okay.
Yeah. And by the way, when we say that we kept it secret, we didn't keep it secret, partly because, if you're dealing with, what was it, 150 people in the office?
Yeah.
there's
no secrets, right. And, there's no secrets anywhere of 150 people. I mean, that's when I see sometimes on signal chats, people say, we should be disappearing messages and stuff because, but you've got hundreds of people in the chat. Well, come on. I mean, be real about this. There's no secrecy in that.
I mean, we kept telling, and they know who we are. We kept saying to them, something's got to give. Don't feel supported. Everything felt very discouraging, and like, tell us then what to do.
So we had to tell ourselves.
My management did a ICE training for us like a number of months ago. And one of the things they said is, don't video ICE because it might escalate the interaction, and you might be putting like the person who's being detained like in danger. You're actually like hurting them by videoing ICE because you're escalating it, and then they're gonna take it out on a person. So
that's gonna escalate.
Yeah, this is management's, or at least that NILAC management's theories of how we should be responding to ICE.
Yeah. But to be clear, none of this is to say that we shouldn't be clear about the law is, right? I mean, we've said that, and we're not saying that that's irrelevant. You know, we all want to know what the labor law is. We want to know what the ICE law is. We want to know what all the laws are. But that doesn't mean we necessarily are going to limit ourselves once we know, you know, with our eyes open. That doesn't mean we will necessarily stop where that is.
But it also means that there are management that are not, with all due respect to what Jane was saying, our current head of the Legal Aid Society and stuff wouldn't hesitate, as far as I'm concerned, to cooperate with arresting
Oh, Twyla, I mean, that.
No, some
We
people
have to have a whole other meeting.
Some
just
people
for
have
that.
to understand and enculturate your own shop with the idea that there are some risks and, you know, how you negotiate or navigate and what management might do certain things. Scott Rosenberg was not one of them. You know, Carter is. So, I mean, that's an important thing to build in.
Rebecca had.
Shelley, go ahead.
Sorry, I just I know we've been here a while, but it sounds like there was a discussion happening around like sort of the guidance that we're receiving from our bosses and management and like what's like the actual position that they take and like are they on our side or not. And I think, you know, based on the sort of the presentation that we got at NILAG and the presentation that it sounds like y'all got at Legal Aid, it kind of goes back to I think a point that a couple folks made, like I think Jane was making this point as well, that is like ultimately management is going to be limited in the things that they can and can't say simply because of what their interests are as management, right? Their interests as management are like, I think inherently on the more conservative side because of these fears that they have around taking risks with the contracts and things like that. But I think that as a result, we as members of the union, as leaders in our union, as like rank and file members, right, we can't abdicate our responsibility to be thinking proactively about how we want to respond and not stay limited to what like the bosses say we can and can't do. And I think the example, like I really, it was really, really empowering hearing from all of y'all. Like I already kind of knew a bit about these walkouts, but getting to hear in detail about it really just kind of like made it all feel so present and really linked it to this moment that we're in. Yeah, I think that even it sounds like the decision to like, okay, like, is this something that we like union leadership is on board for or not? I think that as union members, like, we all kind of have to be thinking proactively about like, okay, what are we going to do in this moment? We are connected to this really powerful, important like body, which is the union. So how are we going to use our position in this to make a difference in this moment and not just kind of take wholesale what our bosses or even potentially right what union leadership says we can and can't do. Um, but yeah, anyway, that was just like a comment that I had in response to some of the discussion that was happening. There were other questions that I had, but I think they were kind of sort of answered. So thanks so much, y'all, for putting on this event, for talking to us.
Thanks, Shelley.
Catherine?
Hey, I figured I'd put my face on here. First, thanks so much, everybody, for getting together and to discuss all of this. And you guys probably don't know me. I'm a former ALAA member. I used to work for Canva. I was in the housing unit there for about a year. And I'm in private practice now. And weirdly, I also moved down to Philly last year, but I still work in New York. And I'm still very much connected to that. And so I went to an anti-ICE meeting with some of the local organizations down here yesterday, and they are in the process of introducing anti-ICE legislature. One of it is keeping the ICE officers out of our courthouses because we do not have that here yet. And so in my discussion with my friend yesterday, I told her that, my old union had did this and then I saw it, and so I joined. And I was really excited that you guys were having this tonight. But I wanted to ask, because I started doing some research down here and I'm still very much trying to connect with Philadelphia organizations here. I don't know that much, but I noticed that there's UAW down here, like some of the collective, with the legal services providers down here. They are covered under the UAW collective bargaining agreements. And so I just wanted to reach out and like ask any of you if you guys know anybody down here, or if like if you know anything about that or like how it works, because I'm trying to find other ways to connect with other attorneys and maybe implement this here so that we can kind of mimic the process that you guys did there in 2016.
Navruz, wouldn't that be 2320?
There might be some civil in 2320, but the Philadelphia Public Defenders are actually unionized in UAW Local 5502.
Oh,
5502. Got it.
you have contact?
Yeah, I can connect with you.
Yeah.
Sure. I'll put my email in the chat and then we can connect.
Perfect. Thank you so much.
I mean, one point that I would make is that I don't know what it's going to look like in New York City going forward, because one thing I thought a lot about is that they were trying to be sneaky and tricky and under the radar in 2017. This feels very different to me, where the point is for you to know about it. So I don't know that we're going to see stuff in the courts. I think it's very possible that we're just going to see, you know, what happened in Minneapolis, where like, I mean, I think you said Sunset Park that there were some,
Yeah.
and I've heard Crown Heights as well from people. So people are already seeing some presence.
The delivery workers in Sunset Park, which have these hubs, had tons of ice crawling over there the last week.
So I actually suspect it's going to look very different, although knowing who the mayor is too, I don't know how that plays out. I just hope that we find ways to rise to the occasion.
I mean, one of the things that I think we're going to see and already have seen is, for years really, is Democratic mayors like the one in Los Angeles and the one in Minneapolis and the one in New York City, socialist mayor. The question is going to be, what's going to happen with the police and the local sheriffs, and how do they relate to the protests against ICE? In LA, they beat up the protesters. In Minneapolis, they have a history, and now the governor is calling in the National Guard, which obviously is to protect ICE from being, to show that they're able to control the protests without it being federalized. In New York City, I mean, it's great that Zoran got elected, but what's going to happen when the rubber meets the road again, and there are mass protests against ICE, as there were the other day at one of the hotels here, and where the police, the strategic response group, came in, which Zoran said he was going to abolish.
That was at the Hilton,
and made arrests, and how is that going to roll out? So again, there's a huge gap.
And Zoran praised the SRG conduct in arresting those anti-ICE.
Right, presumably because they didn't beat people up. They gave desk appearance tickets and summonses instead of, putting them through the system. And it is better to be, given a desk appearance ticket than going through the system. But obviously that's not, we're looking for more than that. And we're not going to accept police from so-called anti-ICE administration, sanctuary cities, being used against anti-ICE protesters, as was so clear in LA, and it's still with both the LAPD and the LA Sheriff's Department.
So thanks so much, everyone, for coming out. I really appreciate hearing from all our panelists. Also really appreciate hearing from Max. He had to log off a while ago, but I'll message him. And thanks so much for all the thoughtful questions and for everyone who came out. I think obviously a very inspiring, important chapter in our local's history in its own right, but also I think very informative for the work and organizing we're doing today. Some of us are gonna grab a drink at Blarney Stone around the corner. So hope to see many of you there. But if not, hope you have a good night.